Welcome to the Tenant Law Podcast, where we talk about new, interesting, and/or important legal cases affecting New York City tenants. This weekly pod will be about 10 minutes long. First, we give you some background so you have the context to understand the case we are discussing. Then we talk about the case itself, and finally, we explain why the case is important and give you our tenant takeaway. I am Michelle Itkowitz, and today's case is Gilbert versus 24th Street LLC, a fairly recent New York State Supreme Court decision. So let's jump right into our context. Every rent-stabilized apartment has a legal rent. That is the rent that the landlord can legally charge. But sometimes landlords actually charge less than the legal rent. And when they do, that can be known as a preferential rent. Now, why would a landlord charge less than the legal rent, especially if landlords are always complaining that rent-stabilized rents are so much lower than free market rents in New York City? Well, sometimes market conditions are such that landlords simply can't get the legal rent. So they can charge a preferential rent and preserve the legal rent if they put the correct language in the lease and register the tenancy correctly at DHCR. So they could preserve the landlord's right to go back up to the legal rent in the future. Well, that becomes the question. When in the future can you go up from a preferential rent to a legal rent? So since June 2019 and the Housing Stability and Tenant Protection Act, once a landlord gives a rent-stabilized tenant a preferential rent, the preferential rent effectively becomes the legal rent for as long as the tenant remains in that apartment, which its rent stabilization could be the whole tenant's life. So when the tenant leaves, the landlord can then go back up to the legal rent with the next tenant if market conditions are better. But the point here is that when a landlord gives a rent-stabilized tenant a preferential rent, the landlord is stuck with that preferential rent, and the Rent Guidelines Board increasing the rent can only go up from that preferential rent number. So that becomes the new anchor. That becomes the new starting rent, the preferential rent. And that can make a huge difference in a tenant's life and in a landlord's, depending on how much lower the preferential rent is than the legal rent. So with that, we're going to jump right into today's case. So in today's case, Gilbert versus 24th Street LLC, a fairly recent New York State Supreme Court decision, the tenant came into an apartment and the net effective rent they ended up paying was $2,400 a month in this rent stabilized apartment. But the tenant's rent stabilized lease and the registration at DHCR said that the tenant's legal rent was $3,745. So that's like $1,300 more. Okay, so the tenant said, well, I have a preferential rent, and I guess my rent should only go up from $2,400. $3,745 really has nothing to do with me because I have a preferential rent, and that's going to last for the rest of the life of my tenancy. But landlord said, no, you don't have a preferential rent. The reason your net effective rent came out to be $2,400 a month was because I gave you these one-time rent concessions just to entice you to come into the apartment. It wasn't really a lower rent. It wasn't a preferential rent at all. So this is the debate between the landlord and the tenant. And it didn't get resolved in today's case. Today's case, why it is particularly interesting, is because what tenant is doing is asking the court to allow it to turn its case into what is known as a class action. A class action is when other people can join into the lawsuit who are similarly situated. So the tenant's opinion that is that the landlord is doing a scam throughout the whole building and that all the other tenants in the building are affected. So the tenant asked the court to make their claim into a class action so that other tenants in the building can join into the lawsuit. And the court here said yes. It would allow the lawsuit to become a class action so that other tenants can join in and debate whether or not the net effective rent is a preferential rent or that's going to last for the life of these leases, the life of these tenancies, or whether it is one-time rent concessions. Now, this gives rise to some very interesting tenant takeaways, but before we get to our tenant takeaways, housekeeping. This is not legal advice. I am not your lawyer. But because I am a lawyer, this might be considered legal advertising. If it is legal advertising, it is terrible legal advertising because I'm asking you not to contact me. This pod is not a commercial for me or my law firm. This is simply the podcast that I always wanted to make. None of this is an answer to your specific legal problems. And if the pod does its job correctly, it will help you ask the right questions. Speaking of questions, email us with your questions. I might be answering listener questions on the pod, not announcing your name, but I would love to say the New York City neighborhood that you're from. If you like our work here, please buy us a coffee on Buy Me a Coffee, link in the show notes, and please give us tons and tons of stars. It is time for the tenant takeaway. Tenant takeaway time. So obviously, rent concessions, especially large ones, when you go into a rent stabilized apartment, should really make a tenant ask a few questions. Is this a one-time concession or is it a preferential rent? Very important question that will make a big difference. Now, here's the thing. Rent stabilized cases are increasingly being successfully and occasionally not successfully prosecuted as class actions. There are a lot of pros to class actions. For one thing, there's usually no legal fees for the tenants. The lawyers get paid only if they win, and then they get paid by the landlord. So no legal fees. And the lawyers involved in these class actions for tenants, these are some of the top people in the city in landlord and tenant law work on the tenant's behalf. So top lawyers without legal fees. Those are some very strong recommendations for joining a class action should you have the opportunity. What are the possible downsides? Well, I have a few criticisms. One is that in the class action context, the tenant can't get triple punitive damages. So in a lot of rents overcharge cases, the tenant not only gets their damages, but they get triple their damages. So if the landlord owes you $10,000, the landlord might really owe you $30,000 if the overcharge is deemed to be willful, but you can't get those kinds of damages in a class action. You can only get your straight damages. Also, class actions take longer, I think, than regular cases because this case we read today was all about the class being certified. So there are many steps. And sometimes I notice the certification of the class goes up to the appellate court, so it can take quite a bit of time on the case. And the other complaint I've heard from tenants is that when they're part of a class action, they don't get as much information and they're not making decisions for their individual life. They're part of a group and the group is making decisions. So there are some downsides, but again, the upsides are great lawyers and no legal fees. So everything in life has pros and cons, and there you have it. Remember, New York City, the law belongs to you, but your ownership of the law is only as great as your understanding of the law. So let's learn to live better. I am Michelle Itkowitz, and this is the Tenant Law Podcast.